My name is Miranda Quevedo, and today I will be helping you understand the competency to waive the right to counsel and represent oneself. What does it mean to be competent? This means that the individual being charged understands the court proceedings. They possess the knowledge and have a factual understanding of what is happening, not just a basic understanding. They are able to work with counsel in order to construct their defense. How is competency evaluated? This is done through the CST standard, a mental health expert who is hired by either the state defense or the court. They evaluate them on a variety of factors, such as their understanding of court proceedings, understanding the charges against them, and their willingness to work with the attorney. Competency to waive the right to counsel. In Godinez versus Moran, did not only find that competence to stand trial and plead guilty equivalent, according to the Supreme Court, but the Supreme Court also found that the person who is competent to stand trial is also competent to waive counsel. According to the majority opinion of the Supreme Court, the competence that is required of a defendant seeking to waive his right to counsel is the competence to waive the right, not the competence to represent themselves. The court also distinguished that the trial judge must determine if the waiver was done voluntarily and knowingly. So it cannot be against their will. They have to do it on their own volition. And here's just a little backstory to Godinez versus Moran so you can better understand what's happening when it comes to competency. It was argued on April 21st, 1993. Moran pleaded not guilty to 3 counts of first-degree murder. 2 psychiatrists who were hired to evaluate him to see if he was competent to stand trial and was in fact found competent. Moran waived his right to counsel, and the court found that he understood the nature of the criminal charges against him while knowingly and intelligently giving his guilty plea. He was sentenced to death. He then sought for the state post-conviction relief. Then the trial court held an evidentiary hearing before they rejected his claim that he was mentally incompetent to represent himself. The federal district court denied his petition for right of habeas corpus, but the Court of Appeals reversed that. The Supreme Court held that the competency standard for pleading guilty or waiving the right to counsel is the same for standing for trial. What is self-preservation? In the case Miranda versus California, the United States Supreme Court held that all criminal defendants have a right to self-representation guaranteed by the Sixth Amendment. Justice Stewart emphasized in the majority opinion that the Sixth Amendment speaks for assistance of counsel and an assistant. However, expert, it is an assistant to thrust counsel upon the accused against his considered wish, thus violates the logic of the Sixth Amendment. The Sixth Amendment. So I'm just going to read it so you can kind of understand where Justice Stewart was coming from. According to the Sixth Amendment, it reads, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Miranda versus California. Here, I'm just going to explain this Supreme Court case so you can understand where Justice Stewart was coming from. It was argued on November 19th, 1974. Anthony Ferretta was charged with grand theft, and the Supreme Court judge assigned the public defender to help represent Ferretta. Ferretta requested that he represent himself, and in fact, in the past, he had represented himself in a previous criminal case. Prior to his trial, Ferretta was inquired about his knowledge about the hearsay rules and other court proceedings. The judge ruled that Ferreira did not make an intelligent and knowing waiver of his right to the assistance. The judge also ruled that Ferreira did not have a constitutional right to conduct his own defense. So that again, it's just the background of the Supreme Court case, just so you can kind of get a better understanding. What is self-representation continued? In the defendant, if the defendant decides to be acting to their own determinant, they decided to proceed pro se. Although they proceeded pro se, the court understands the value of free choice and its worthiness. Although choice can increase the risk of criminal punishment. So they know, well, they do have a constitutional right to represent themselves, even if that risks them landing in jail. The right to self-representation means that some defendants will conduct their own defense. According to Melton, a criminal defendant's ability to represent himself has no bearing upon his competence to choose self-representation. What does waiving the right to counsel look like? The evaluations of waiver of counsel and competence to represent oneself do not usually take place during a typical competence evaluations. The clinician evaluating the defendant will conduct a standard competence to proceed evaluation. This is what usually entails asking the defendant if they know the disadvantages of proceeding without an attorney, so they know the risks, while also assessing the defendant's understanding of the tasks attorneys perform, such as jury selection, opening and closing statements, and questioning the witness and objecting. So basically what we all see on TV court, we all see what the attorneys have to do for their clients. So they need to know that they are running the risk of not having a seasoned lawyer help them out and know when to object, etc. The clinician would then ask why the defendant wants to proceed pro se, while also keeping an eye out if the reason is being made due to mental disorder. So if they decide to proceed pro se due to a mental disability, disorder, etc., then that, of course, would come into play about them being able to represent themselves in court. Here's my discussion question to you guys. Given what the majority opinion in the Supreme Court case of Godinez versus Moran, do you believe that if the defendant is competent to stand trial and has the competence to waive their right to counsel, should they also be competent to represent themselves? Do you think that competency evaluations are necessary? Why or why not? So that's just a question that kind of gets you guys thinking. Like, if they can do this, that, and the third, why should they be able to do the last thing? As in, even if they are competent to waive the right to counsel and competent to stand trial, should they also be competent to represent themselves, or should they have an evaluation? And here are just my references. I hope this helped you understand the competency for the right to counsel, to waive the right to counsel, and for self-representation.